Hi, so we're going to look at intent to create legal relations within contract law. This is a nice, short, straightforward, easy topic if you know the trick. So the trick is to understand why this would be brought up in court. So intention to create legal relations is a really key element towards forming a contract. I would argue there's three. So an agreement, which consists of an offer that's then accepted, some form of consideration, and then this, the intent to create a legal relation. And it's this that distinguishes a legally binding contract from the informal agreements that we make every single day. So you will often make agreements with your friends, family, and you don't intend for them to have legally enforceable consequences, and that's the key. That's what's really important. So for example, if you ask someone to pick you up after work and then they can't, you probably don't think, well, I'm going to take you to court to make you do that. The court would be filled with pointless, frivolous claims if that was allowed. If you were a kid and you asked your parents, could they buy you this toy, and they promised yes, and then they go back on their word, again, you probably aren't thinking, I'm going to take them to court. And that's because these agreements were never meant to be legally enforceable and have those enforceable consequences. Now, there can be moral consequences, of course. So for example, if you make agreements with your friends to meet up for coffee and they keep standing you up, they keep cancelling, that might have moral consequences. So you may not want to be that person's friend anymore, but it wouldn't be legal consequences. When it has legal consequences, that's when we can use court or other forms of alternative dispute resolution, but that's when we can start to really enforce what's happening. So what will happen here is that we'll have a dispute between the two parties of a contract. One person will be saying, I meant for this to be legally binding and therefore you haven't done your part, so I can sue you to make this happen. The other party will be disputing this and saying, I never meant for this to be a proper legally binding contract, and therefore I don't have to do what we said, and you can't take me to court because there's no point. So the court will be asked to step in and to look at the agreement that was made and to determine whether they thought both parties entered into it with a legal intention. And that's important because of freedom of contract, so people have the freedom to make whatever contracts they wish. The idea is that if you enter into a contract, both of you enter with the same intention. You both have the same understanding of what you're going to do, what's binding, what's acceptable, what's not. So the first thing that the court and you would need to do in an exam question is to determine the context. What is the background of the relationship between the two parties? So is it business or commercial? So for example, is it between employer and employee? Is it an agreement between two businesses? Is it commercial? So is it about selling things? Is it one person selling something and another person buying it from them? Or do we think that it's more of a social or domestic relationship between the two parties? So for example, they are friends, or they are family members, or they are husband and wife or spouses. That's going to be really important, because what the courts will then do is then, once they've determined the context, they will start with an initial presumption. It's a starting point to help them with their findings. So if it was a business or commercial relationship, the starting point was that both parties probably went into it intending for it to be legally binding, because that's what we tend to do in businesses or when we're buying and selling things. We tend to mean for these to be legally binding. However, if it's between friends, family, loved ones, etc., the starting point is that we think that people probably don't mean for those sorts of agreements to be legally binding. So maybe morally or binding out of love and affection, but certainly not legally binding. Now that's a starting point, and that's the starting point for you to state. So point 2 is easy peasy. Once you've determined the context, simply state the presumption for the court will be that it is or is not binding, depending on which one you're going for. Now then, what will happen is that we need to have a look for any evidence that counters this. Now, the burden of proof to bring this evidence is on the party who wishes to rebut that presumption. Now, rebut just means change, overturn, reverse. So in other words, you might be arguing that although you made that contract with a friend, it was meant to be a proper legally binding contract, and therefore you would need to bring the proof to court of that. Similarly, a business might argue that we didn't mean actually for that to be a proper contract, and they would have to bring the proof of that. So what they're trying to do is they are trying to convince the court, they're trying to convince the judge that the evidence that they have is strong enough to challenge that initial presumption. So for example, when it comes to a business or a commercial agreement, Edwards versus Skyways is a really good example of that. So this was where they promised a member of their staff redundancy money. Now that wasn't something that they legally had to do. They already had legally a package in place to support him, but they promised him an extra payment. And when it came to actually paying it, they refused. And the basis for that, they said, was they weren't legally bound to do it. It wasn't part of any legally binding contract. When they said it, they didn't mean to create any sort of legally binding consequences. Of course, the employee, Mr. Edwards, he argued against that because he operated on the understanding he was going to get that money for his employer. Now, the courts looked at the starting presumption. Promises made in employment, in business, they tend to be binding. So it was up to Skyways to prove that their evidence was strong enough to overturn this and show they didn't mean it, and the courts weren't convinced. So even though it was a voluntary payment, they did not have to make that promise. The fact they made that promise and it was made in a sort of a business employment environment suggested that it should be binding. Business is also trying to do this with gifts and say that actually gifts aren't part of a legally binding contract. They're not something that we intended to be legally enforceable, and the courts have not found evidence to overturn this. So Carlisle, they tried to argue that the extra payment if you got the flu was a gift that wasn't meant to be legally binding. That was ignored. Similarly in Esso, where they were talking about the sort of transactions with the World Cup coins, that was ignored. And also McGowan versus Radio Buxton, they said that even though they may think it's a joke, it's a business transaction and the customer would understand it to be legally binding. The evidence wasn't strong enough to overturn this. An example where it was overturned was a letter of comfort, and this was seen in the case of Kleinwort. So a letter of comfort is a sort of assurance that a business has enough money. That is not legally binding. If a business wants a legal guarantee, they should ask for one in the course of making the contract. So this was seen as strong enough to overturn the presumption. Now, if it's the social or domestic contract, we don't tend to think it's legally binding, and this was seen in the two contrasting cases of Balfour versus Balfour and Merritt versus Merritt. Now, in Balfour versus Balfour, that promise to pay was made during the marriage. It was made out of love and affection, and it wasn't seen as a thing that both parties thought they'd be held to. However, in Merritt versus Merritt, they'd already split up, so the court said that that was strong enough evidence that it would be. A key evidence that seems to overturn the presumption is where a person has financially relied on that promise. So for example, in Simpkins versus Pays, this was a lodger, not quite the same as a friend or family member. They were relying on that money. Parker versus Clark is a very strong example of that, where a young couple had sold their house on the promise of their aunt and uncle giving them their old one. Now, the fact that, okay, we start with the assumption that it wasn't intended to be binding, but the evidence that they'd sold their house was strong enough to rebut and overturn this and prove actually when they made that agreement, they would have had intention to create legal relations. Sometimes it's really, really unclear between the two what it is. In those cases, Sadler versus Reynolds told us that common sense, if you want to prove it, you have to do it. So it's up to the party who wants to challenge what it is to prove what it is. So if you want to prove that you think actually even though it was an agreement between friends to write a book, that was a legally binding contract. If you want to show that, if you want the courts to decide that, you have to bring the proof to convince them to do that. And in that case, they did manage that. So really quick whistle stop tour. There's really not a lot to it. Just follow the 3 steps and it should be a really easy topic for you. Thank you for watching.